Can you hear me? All right, you're looking, so I think you can. I'm Judge Nina DiPietro. Thank you. I'm going to be conducting your magistrate hearings this morning, so when you hear your name, please step forward. What would you like to call?
I have Amelia Sanchez, Your Honor. Ms. Sanchez is on page 3, and it's...
All right, give me 1 second. Let me find it.
Oh, she got her arms back.
You said page 3?
Page 3, yeah. Ms.
right.
Sanchez.
Oh,
Yeah. I think the state and I have agreed to the $750 if that's acceptable to the court.
I got it. Here we go. Okay. All right, so real quick, good morning to you, Ms. Sanchez. You're here on 1 count of driving while licensed suspended habitual, and it looks like also a ticket attached to that. Based upon my review of the probable cause affidavit, I do find probable cause. Your attorney is here this morning representing you. It sounds like there's an agreement relating to bond.
Yes, Your Honor.
Okay, all right,
Okay.
so I will impose the $750 bond that has been agreed to by your attorney and Mr. Linder, and so good luck to you, ma'am.
I'll be calling Brad again. Okay, Amelia? I'll see you tomorrow.
Good morning.
Okay, thank you, Your Honor.
Yep, have a great
Let's go.
day.
Okay, bye.
All right, anything else? Yes. Oh, you're with him? Okay, all right. You're in a case? What's that? Oh, okay, no problem. All right, so we'll start with the docket. Patricia Lane,
North Broward.
thank you.
Ms. Lane would like to resolve this case if possible, Judge.
Let me take a look. All right, good morning to you, ma'am. You're here on 1 count of resisting an officer or obstructing without violence. You're also here on 1 count of trespass. Based on my review of the probable cause affidavit, I do find probable cause. It's my understanding that you want to resolve the case today, is that correct?
Yes.
All right, state what's your position on resolving or resisting without?
My only concern is I'm showing she's got an open case. She was ROR'd last month for literally the same exact thing at the same exact location.
And it's a pending case?
Yes, it's been filed.
All right, here's what I'm gonna do. I am not gonna revoke your bond on the other case because you were given an ROR. Since it's an open case, it is a violation of that pretrial release condition to pick up a new offense. What I will do, though, is that I'm not gonna resolve this today. As far as, there's a $100 bond on count 1. I'll leave that in place, but you have to make sure you come back to court. So I'm not gonna resolve your case today. I'll let the state attorney's office make a filing decision, and, as far as
If you send this one, the other one will. No.
all right, hold on. The attorneys are gonna have a quick discussion, and based upon that, they might tell me something, they might not. You guys wanna tell me anything?
As long as you're leaving the bond in place, we would ask that Ms. Lane's cases be transferred to Judge Lerner Wren.
Oh, that's fine.
And I don't know that the other one can be transferred from here, but once this one goes, I'll let my office
Okay.
know and they'll send the other one.
Okay,
And I'll call your daughter for you, okay, Patricia?
okay. All right, so I'm gonna leave the bond at $100. No requirement for bond on count 2. I am not revoking your bond on the other case, but, as far as this case, I am gonna transfer it to Judge Lerner Wren, okay?
And I'll be asking the court to sign an order allowing our office to take photographs of Ms. Lane.
That's granted. All right, good luck, ma'am. All right, I have Luzon Suki or Suki. Okay, thank you. All right, next I have Shannon Grog.
Ms. Grog, come on up, please. She's approaching, Judge. She's your name.
Okay. Thank you. Got it. And I sign it as the relinquishing division? I'm not the accepting, relinquishing, here we go. Okay, got it, thank you so much. Just wanna make sure I sign the right place. Okay, I apologize, Ms. Grog, you're here this morning on a violation of probation. There's a no bond hold with that. You're gonna see your judge on the 19th at 8:30 a.m. Good luck to you. Okay, I have Wendy Montilla, or Montilla.
North Broward.
Hi, good morning, ma'am. You're here on 4 separate counts. The first is violation of probation. There's a no bond hold with that. You also have 3 separate capiases. There, it looks like 1 felony case with 3 charges. Those are also listed as no bond holds. And I'm just gonna check real quick and see if I have to do anything with these. Are these, do I have to set bonds, or was this a failure to appear?
These are failures to appear. I believe.
Okay, yes, so it was a no-show at arraignment. So ma'am, I have no ability to even address the bonds in this case. They're all set at no bond. However, you are gonna be going before your judge. You have a court date on January 2nd at 9 a.m. All right, so good luck, ma'am, I'm sorry.
Thank you.
All right, Maria Gomez?
Ms. Gomez is here at main, Judge?
Okay. All right, I've been informed that her bond has been posted. That's correct?
Yep.
All right, no problem. I'll leave the bonds as is so she can continue to be bonded. All right, Ty Alberga?
Ms. Alberga, come on up.
Okay, good morning to you, ma'am. You're here on some tickets as well as 2 violations of probation. The violations of probations are no bond hold, so I can't address those. You will see your judge on the 18th at 9 a.m. All right, good luck, ma'am. All right, I have Alexis Sapp. All right, good morning to you. You're here for 2 separate counts.
Under Judge.
Oh, bonded?
I was gonna say that.
Okay, well, there goes your PC arguments. I know. Okay, well, you can try on this one. All right, Dominique Lax, is that you, ma'am?
Yes.
Okay, all right, great. So you're here on 1 count of carrying concealed firearm, and 1 count of resisting an officer with violence, and 1 count of resisting or obstructing without violence. Based on my review of the probable cause affidavit, I want to hear from both parties as far as probable cause. As far as the carrying concealed firearm, I mean, it's partially concealed, partially not
Well,
concealed.
there's case law I can provide the court
Okay.
that covers this.
That covers it being partially? Okay, do you
Even-
dispute that?
Actually, even
Okay.
not partially, it covers it, but if,
Okay, well, he's not disputing it, so that answers that question. So I'll find probable cause as it relates to carrying the concealed firearm. On here, I put a note where it says it just attempted to push. I guess, was that the totality of the resisting
and I
with?
think that's more of a bond issue. I mean, because basically the statute does cover even an
An
attempt.
attempt, okay.
That is correct, Judge, but
Okay.
it's certainly something that you can take into account when deciding what an appropriate bond would be
Sure.
for Ms. Lax.
Okay, so, based upon the arguments, and the information provided to the court, I am gonna find probable cause for all 3 counts, and we can talk about bond as it relates to them as well. So what's state's position and defense position on bond?
One moment, Your Honor.
Sure.
I'm showing that Ms. Sapp is out on bond right now for failure to return a hired vehicle.
Is that a misdemeanor offense,
a
a
felony.
felony? Okay, what case?
16. I'm sorry, Ms. Lax, sorry.
Okay, yeah, let's definitely check
No,
that.
it's definitely Ms. Lax.
And
It's-
she's out on bond, pretrial release, or
it's-
what?
It's bonds, city bail bonds,
Okay.
from May 20th, May 20th of last year.
And what's the case number?
165544 CF10A.
165544 CF10A?
Yes, Judge.
All right, what's your position on bond on this case then?
Your Honor, based on the totality, on count 2, I would just be asking for, I'd be asking for a $500 bond.
Okay, defense?
Judge, in speaking with Ms. Lax, she's been here for 1 day. She actually drove down from Indiana. She has a court date scheduled for next week. She's been going to court, I believe, for over a year, back and forth, meeting with her assigned attorney. From my understanding, either her attorney's going to be filing a motion to dismiss next week on the case, or it's already set. I'm not sure. However, in saying that, Judge, she hasn't missed any sort of court. Is living in Indiana. She's self-employed. She sells swimsuits. She makes approximately about $100 a week doing that. She lives in the city of Muncie, which is located in Indiana. She lives with her mother. Her mother is retired, so unfortunately her mother doesn't have like a vast amount of financial resources. We'd be asking you to set a bond on count 2 of $100. Leave the standard bond in place on 1 and 3. She thinks that her mother will be able to go ahead and come up with that much money. And I'd ask you not to take any action on the 2016 case, considering it's almost a 2-year-old case. She's been going back and forth. She's been in constant communication with her attorney. So, Judge, at that time, certainly she has a scheduled court date next week, which at that time the state could file their own motion if they think it's warranted, or the judge at that point could take action if the judge thinks it's warranted. So at this time, we'd just be asking for a $100 bond on count 2.
A couple things, Your Honor. One, she does not have a hearing next week. Her hearing is scheduled for January 5th of 2018. I see at a minimum at least one waiver of appearance.
Waiver?
A waiver of appearance, so she wouldn't have to appear.
Got it, okay.
I don't necessarily see any other hearings that she would have necessarily been required to be at. So I don't, yeah. So, I mean, that's, as far as the representations that she's down here for a hearing next week, that wouldn't appear to be accurate.
Okay. You know,
And a motion to dismiss has been filed, stating that the contract originated in Georgia, and that's where the vehicle was actually rented. And the motion goes on as to, so there's a motion to dismiss that needs to be litigated. It's a pretty lengthy motion. I don't necessarily want to get into all of it,
Right.
but it does appear as though the contract for the vehicle was signed in Georgia, not in Florida, so there could be jurisdictional issues. There could be a lot of other things going on in Ms. Lax's case. So I would join in my colleague's request for the court not to take any action on that outstanding case.
And I would also know the state has filed a motion to strike said motion to dismiss.
So as I said, there's a motion to dismiss yet to be litigated.
Well,
Just saying,
I
if we're
mean,
talking
it'll be
about-
litigated
I'm
in
just
both.
saying, if we're talking about what's filed, then, I
Okay.
mean, what, I
Well,
don't know
in
what's
any
relevant.
event, you know, my concern is, first and foremost, obviously, I'm looking at the probable cause affidavit. And while certainly she's not charged with any sort of aggravated assault or anything to that effect, there's an allegation that the reason why the police officers even came to contact her was that there was a call-in for a female waving a gun in a car with a child. And so that obviously piques one's interest, although, like I said, she's not charged with any sort of crime relating to that, but they did then find the gun in the car and a child in the car. So as it relates to this case, you know, my concern is more so than just is she going to come back to court, given that she is not a resident here, and there might be some inconsistencies with her statements and what's in the court file as it relates to coming to court or not coming to court or when her court dates, and that could just be some confusion as well. But it's also the safety to the community. But in any event, as it relates to this case, what I'm going to do is I'll grant, the state has requested only a $500 bond on count 2. I'll grant that. I'll deny defense's request for a $100 bond. So in this case, it's going to be $1,000 on count 1, $500 count 2, $100 on count 3. As it relates to the other case, though, I am going to be revoking the bond. I mean, I can understand that there may be arguments to be made. In fact, in almost every case that there is a pending case that's out there, there may be arguments very good or substantive arguments to be made about a case. I'm not sure, but I mean, that'll be litigated in front of her judge, and if she has a hearing coming up, this can also be addressed. But I am going to be revoking her bond on case 16-5544CF10A. That's pursuant to Florida Statute 903.0471. So you'll have a no bond hold on that case. You'll go see your judge, but unfortunately, a condition of bond is that you not get rearrested while you're out on bond. So good luck to you, ma'am. Okay, Aaronetta Sanders, is she back yet?
No, Your Honor.
Okay, we'll should we be doing, do you want to do a probable cause?
Well, no, it was.
We already did, I
costs are
think.
already determined. We're just, at this
Oh,
point, we're just
okay,
resetting for
'cause
bond.
It's not signed off on.
Oh, well,
Well-
is it checked?
Oh, you know what, it was Judge Miranda did.
There's a
Okay.
bunch of. there's a
Gotcha,
bunch
okay.
of-
All right, got it. All right, Jermaine Fuller?
Yeah.
He's in North Broward, Judge. He'd like to resolve this matter if possible.
Okay, give me 1 second. There you are, sir. All right, good morning to you, sir. You're here on 1 count of trespass and 1 KPS and misdemeanor. It looks like a traffic offense. Based on my review of the probable cause affidavit, I do find probable cause for the trespass. Let me take a look and see what's going on here, and I'll hear from both state and defense as it relates to resolving the case. Let me see. And it looks like the warrant, I'm just trying to see what the warrant is for.
It's a 2012 case,
I got it.
Judge.
Solicitation.
Okay, so let's got it, okay. All right, what are your positions on resolving the case?
I have no problem with the court resolving the case. He does have a lengthy history. Most recent stuff is all low-level type stuff. He does have prior convictions, but that being said, however the court wants to resolve
So
it.
there's a packet in here where Judge Miranda already found probable cause. Yeah, this has been brought back a bunch. There you go. Sorry about that. Okay, as far as if you want to resolve the case today, sir, I can do that. I would be offering you an adjudication, credit for time served, and court costs on both cases. Is that something you're thinking of?
Yeah, it's good.
Okay, all right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, all right. All right, so as I said before, you have one count of trespass. You can put your hand down. You have one count of trespass, and the other count is for some sort of panhandling or solicitation, okay?
Yeah.
All right. And you understand that if you resolve your case here today by a no contest plea, then that means that on both cases, you're not going to have a trial. You're not going to be fighting those charges.
Yeah.
Okay. All right. And do you understand that that there isn't going to be any further court dates on this?
Okay, yeah.
Okay. All right. Just making sure. All right. Are you doing this freely and voluntarily?
Freely or voluntary doesn't
I
matter,
can-
right?
Well, no, I can. It does. It makes a big difference to me, and I'll explain why. Do you feel like anyone is forcing you or making you do
No,
this?
no.
Okay.
Not really.
Are you doing this because it's your choice? You want to resolve the case?
Yeah.
You feel
Yeah.
like it's in your best interest to resolve these cases?
Yeah.
Okay. Do you have any questions you want to speak to a lawyer about before I resolve these cases?
Why would need a lawyer? Like, that's a.
We have spoken, Judge.
Okay. Well, let me ask you this. So you spoke to Mr. Reedy. He's a public defender. He's a lawyer here that spoke with you earlier. Do you need
On the phone, right?
Yeah.
Yes.
Do you need any more time to talk to him?
Not really.
Okay. Do you have any other questions for him about these cases?
Not really.
Okay. Well, you say not really. Any?
You say, play no contest, resolve the case, court calls, so I think the case is over. So
And you get out of jail.
Yeah.
and then get out of jail today, right?
Yep. That's
Okay.
correct. So long as you have nothing else
Fine.
holding you and I don't see anything.
Time served, right? Okay. Thank
Okay.
you.
All right. So I will accept your plea of no contest, and I will
Yeah.
give you an adjudication plus court costs plus credit for time served on both of your cases, okay? I can't take away the court costs. I can give you a year to pay.
Okay. Yeah, I'll pay it.
Okay, just go to the clerk's office when you get a chance after you get out to
So
pay
it's
it.
only two charge, right? It's only two charge, right? The
That's
trespassing
correct.
and the warrant.
You got a
Okay.
trespass, and then the warrant charge was a solicitation as far as money,
Okay.
okay?
Okay.
All right, take care. Bye-bye.
Good luck, Jermaine.
What's your name, Judge?
Nina.
Nina, okay. Thank you.
Bye now. Bye now. All right, David Carroll? Hi.
Mr. Carroll, President.
Whenever you're ready, let me know.
This is on Mr. Marino, James Marino.
All right, just let me do Mr. Carroll since he's already up, and then I'll go to yours, okay? All right, so Mr. Carroll, good morning to you. You're here on one count of trespass. You're here on two separate municipal ordinances. I'll give you those exact charges, and also illegal possession of a shopping cart. On the municipal ordinances, one is open container, and the other one is indecent behavior, which was urinating in public. Based on my review of the probable cause affidavit, I do find probable cause. As it relates to bond, or is he looking to resolve the case?
Judge, and speaking of Mr. Carroll, he does wish to resolve the case.
Okay.
It's a little bit hard of hearing, so that's why I'm speaking louder than normal, but he does wish to resolve his case for time served today.
Okay, all right. And state, what's your position?
State's offer, frankly, at this point, would be, based on the allegations, would be adjudication on counts 1 and 3, adjudication 5 days. Mr. Carroll has been through this division quite frequently. His history, I'll just give you the arrest dates. October 15th,
Of this year?
this is all this year.
Okay.
July 26th, July 21st, April 26th, March 5th, March 3rd, January 9th, then 1, 2, 3, 4. Just a minimum over 30 arrests that I see in his past in Broward alone.
Okay.
And also noting, Your Honor, this wasn't just a matter of being somewhere we are not supposed to be. It's also, I think, it's a little concerning the actions he was taking, considering this location. And,
I understand what you're saying.
yeah.
Well, here's what I'm gonna do. Mr. Carroll, I don't know that even giving you 5 days in jail is gonna make a difference if you're gonna continue your behavior. That's gonna be up to you, okay? I hope that you stop doing whatever it is that you're doing that continues to bring you here. I don't know what the other charges or arrests were for, but I hope that this is not gonna continue to be a pattern. And again, I could give you 5 days in jail, which is what the state is asking for, but I'm not sure if that's going to make a difference to you. That has to be in your mind, whether that is a sufficient enough penalty to keep you from doing it or not. I'm not sure that it would be. So I just hope that here on out you try and make some changes so that you don't continue to come back here. What I'll do is this. I'm going to resolve your case to an adjudication, court costs, and time served, because realistically, I don't know if additional time here in jail is going to make a difference, and I don't know that the taxpayer should have to pay to keep you in jail for those days if it's not going to make a difference. But I hope that going forward it will, but I'm giving you an opportunity to get out today. So I will resolve your case to adjudication, court costs, time served, despite the state's offer. Is that what you want to do?
Is that what you want to do?
Yes, ma'am.
All right, and if you can't hear me, you just wave at me and I'll talk louder. I'll move the microphone.
He's translating for me. when you say something, he repeats it so I could hear it.
Okay, well, how about this? I'll just talk a lot slower and I'll talk louder. Is that better?
She's saying she'll talk a lot louder and slower. Is that better?
I could try. I heard, is that better? So you must have said that pretty loud.
Okay, sir. If I can have you raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. All right, if you would like to resolve your case today to a no contest plea to all charges, I will do that in exchange for adjudication on all cases, court costs, which is something I have no control over, and credit for time served. Is that what you would like to do?
Is that something you wish to do?
Yes.
Okay, and do you have any questions for Mr. Romero, the attorney there, before you resolve this case?
Do you have any questions for me before you resolve the case?
No, ma'am.
Okay, do you understand by resolving your case here today that you will not have any further court dates or opportunities to fight these charges?
Do you understand by resolving the case today, there will be no future court dates regarding this case and
Yes,
the
ma'am.
opportunity to fight it?
Yes, ma'am.
Okay, are you doing this
No
freely?
contest is the same as a guilty plea. So
Well, it's a little bit different, but it results in the same thing today, which would be the same sentence. Okay, are you doing this freely and voluntarily?
yes, ma'am.
Okay, is anybody forcing you or making you enter this plea today?
No.
Okay, I will accept your plea of no contest to all charges. You are going to be adjudicated and given court costs and time served for each charge, okay?
Okay.
All right, good luck. Please don't come back, sir. All right,
If we could call
Oh, yeah.
James Marino.
yeah.
Felony, sorry.
How, give me an idea where it might be in the stack.
Ugh.
I just
Oh, perfect.
flipped to it.
And, Your Honor, we actually have a stipulated agreement if the court
Okay,
is.
all right.
He's on page 13.
Okay. All right, good morning to you, Mr. Marino. You're here on one count of exploitation of an elderly person, $20,000 to $100,000, and one count of grand theft, $20,000 to $100,000. Based on my review of the probable cause affidavit, I do find probable cause. You have your attorney who's here present. You can see through this screen. He's negotiated a bond with the prosecutor this morning, so I'll hear about that now.
And just for the record, Your Honor, this was negotiated between Sarah Gresham, who's is signed to the case, and Mr. Hecker. My understanding, and Mr. Hecker can confirm this, it's $10,000 per count with an order of no victim contact. The name of the alleged victim is Yetta Gilbert.
Okay.
That's correct, Your Honor. Scott Hecker on behalf of the defendant.
Okay, all right. Well, I have to say you're lucky, sir, because they negotiated a bond which I'm gonna honor, although I would have been considering a different bond if that wasn't the case. But I will honor the agreement between the state as well as your attorney. So I'll give you a $10,000 bond on count one, $10,000 bond on count two, and then no contact with the alleged victim in the case. And her name again?
Sorry, Yetta Gilbert.
Yetta or Getta?
Yedda, Y-E-D-D-A.
Yetta Gilbert. You may not contact her directly or indirectly, other than through counsel, through depositions or other types of court proceedings, okay?
Thank you, Judge.
Thank you, Judge.
All right, have a nice day. Okay, Timothy Kylo, or was there, hold on.
Kylo, come on up.
All right, I'll do this and then I'll see. All right, good morning, Mr. Kylo. You are here on a capious misdemeanor. It looks like a trespass case. There's already been a probable cause determination on that. Is he looking to resolve his case today?
He is, Judge.
Okay, raise your right hand, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, all right, let me see here.
This was allegedly from October 18th, allegedly trespassing at a Five Guys on 150 South Federal Highway in Deerfield Beach.
Okay. All right, sir. If you want to resolve your case, does he have prior adjudications, withholds, what?
Yes, he has prior adjudications. I believe he was just here within the past couple weeks on a similar offense.
Okay. All right, sir. If you want to resolve your case today to a no contest plea, I will resolve it to adjudication, court costs, and credit for time served. Is that what you want to do?
Yes, ma'am.
All right, you can put your hand down. There you go. All right. And do you understand that if you resolve your case today, that you're not going to have any further court dates or opportunities to fight these charges?
Yes, ma'am.
All right. And do you understand that if you need more time to speak to an attorney, I can give you more time?
No, I just think I'm okay.
Okay. All right. Are you doing this freely and voluntarily?
Yes.
All right. Is anybody forcing you or making you enter this plea?
No, ma'am.
Okay. I will accept your plea of no contest. I'm going to give you an adjudication, court costs. I'll give you 1 year to pay and credit for time served, okay?
Yes, ma'am.
All right, good luck.
Okay, thank you.
All right. Joshua Desravines. Thank you. Oh. Here you go.
Judge, I've been informed, you bonded?
Oh, okay. Thank you. Do you have something to call? Okay. Good morning. What's the name on it?
Thank you. Judge, it's Frank Jarrell.
All right.
It's,
Oh, got it. It was coming up. Yep.
yeah.
All right. Okay, good morning to you, sir. You're here on one count. It's a KPS, a misdemeanor offense, actually a municipal ordinance. It was a resisting or obstructing without violence. There's already been a probable cause determination. Let me take a look real quick here. Okay, so this was a no-show KPS, so I'm not allowed to do anything as it relates to bond. Is he looking to resolve it, or?
Yes, Judge, it was just a matter where it seemed as if he interfered with the police arresting someone.
Okay, I mean, I don't have a probable cause affidavit, so. What's the last name,
Jarrell.
Jarrell, Jarrell.
Mr. Jarrell, would you like to resolve this matter today?
Yes.
All right. Do you know if he has any prior convictions on his record?
It's 181194.
Sorry, what was the number again?
181194.
All right, yeah, based on the number, I'm guessing yes. His most recent arrest was July 24th. Yeah, I don't know what happened with that, but yeah, he had a resisting without violence last year that he was adjudicated on.
Okay. All right, sir, if you want to resolve your case here today to a no contest plea, I'll offer you an adjudication, court costs, and credit for time served. Is that what you would like to do?
Yes, ma'am.
Okay, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. All right. You have an attorney here. Do you need any further time to talk to him before you enter a plea today?
No.
Okay, all right. And you understand that if you enter a plea today, that you're not going to have any further court dates and you're not going to fight the charges?
Yes.
Okay. You understand you won't have a trial date either?
Yes, ma'am.
Okay, just making sure. Are you doing this freely and voluntarily?
Yes.
All right. Is anybody forcing you or making you enter this plea today?
No.
Okay. All right. I'll accept your plea of no contest if that's what you want to do. I'll give you an adjudication, court costs, 1 year to pay, and time served, okay?
Yes, ma'am.
Okay, good luck.
Thank you, Judge.
Anybody else? No? Okay. David Sutton?
Yes, ma'am.
All right, good morning.
President Maine, he declined the service of public defense.
Okay, all right, Mr. Sutton, you're here on one count of petty theft. Based on my review of the probable cause affidavit, I do find probable cause. Let me see here real quick if there was recovery. All right, it looks like there were, well, it was out of Publix. Seems like there was recovery. There would have been.
Yeah, it seems that way,
Okay, sir, you don't have to say anything. You don't have to.
It also mentions he was very cooperative with the investigation.
Okay. Do you have any priors?
Would you let the judge know?
Okay.
Yes, Your Honor, he does have priors. He was arrested on November 20th for possession of Xanax and drug paraphernalia, but they're not, filed no information on.
Okay. Any convictions on his record? Anything like that?
Yes, Your Honor. He has, 1 second. Loitering, 2010.
9160 CF10.
Another possession of cannabis, 2000.
Are they convictions? Withholds what?
sound like they.
Withholds. He has no convictions at all. Would he be eligible for a program of some sort, or?
He might be. I can't guarantee that he would be.
Understand. Okay. All right. So you have a couple options today, Mr. Sutton, okay? The reason why I'm inquiring is to find out if there's a potential that based upon the nature of the charge and your criminal record, you might be eligible or potentially eligible for some sort of program. Why that's important is because if you are, and I have no idea, and the state cannot confirm to me whether you would be or would not be, but if you are, that might be something you want to consider so that you can bond out, fight the charges, or go into a program, something of that nature, if that's available to you.
I'm actually being entered into a private program, Satori Waters.
Is that
I had to wait about
like a treatment program of some sort?
Yes, ma'am. Yes,
Okay.
ma'am.
Well, when I say a program, I mean a court program that would relate to your charges and the outcome of your charges. So not a separate independent.
I'm still in decisions with that with my attorney.
Oh, you have an
You know what,
attorney
Your
on
Honor,
this?
'cause it shows here, he is in drug court, felony drug court.
Pending?
Yeah, I haven't hired him yet. Like on this case.
All right, don't say anything else.
Yeah.
Let me double check to see what's going on with it.
Don't say anything else. It's not in your best interest to talk any further for right now.
See what's going on with it. It's a 2014 case, if that's the one he's talking about.
Yeah. Because he was caught in Dade County. Like the same was caught in Dade County.
But there's no there's no disposition on it?
Order remanding defendant to court, that's all I see.
To court or to custody?
Eric, do you want to check this out on state safes?
What am I checking out?
Drug court, she's asking you questions.
Well, I understand. Well, what would you like to know, Your Honor? As far as
It shows that he's in drug court.
okay, but what's the case number?
14. 3639 CF10A.
It's disposed.
It's disposed?
Yeah, it was
Court.
disposed of April 26th of this year. It was dismissed.
Okay, all right. Okay, so we just wanted to make sure that you didn't have any open or pending cases right now other than what you're here before the court for this morning. I mean, if you want to resolve the case today, I'd be willing to resolve it. If you want to talk about bond and getting out, and that way you can fight the charges, we can talk about that as well. What would you like to do?
What's the best way to resolve it? Get me out today?
Well, I mean, I can offer you a plea that can get you out today, or I can offer you a bond that can get you out today. So you have two choices. The difference being,
I'll take the bond.
you'll take the bond? Okay, there's a $25 bond on this. Can you make that?
Yes,
Oh,
I'll try. It's gonna be hard, but I'll try.
okay.
I don't have any money on my personal.
Do you think you can call someone?
I can try. I just got a job 2 days ago doing security downtown.
Okay.
I get paid tomorrow.
All right,
That's
well,
not until tomorrow, and I'm in jail. So
well, is there anyone you can call that can get you out on the $25 bond?
I'm not sure.
All right, well, what I'll do is I'll just leave it as $25, and that way, hopefully, you can get out and you can fight the charges, do programs, whatever's available to you, okay? All right,
Thank you very much.
good luck. Good luck in your recovery. All right,
Thank
Jonathan Baggett,
Mr. Baggett is here, President Judge at Maine. He declines services as a public defender.
thank you. All right, Mr. Baggett, you're here on defrauding an innkeeper under $300. Based on my review of the probable cause affidavit, I do find probable cause. There's no recovery on this. All right. Did you want to say something?
Your Honor, I'm going to be requesting a bond increase to $100. Mr. Bethel was just arrested about 6 months, Mr. Baggett, sorry.
Baggett, okay.
Yeah, no, I was looking at the road apparently is from in Alabama, sorry. He was arrested about 6 months ago for the same thing. He was charged with an MO, eating about and drinking about $50 worth of food and drink from Rock Bar in Fort Lauderdale and not paying.
All right, sir, how much bond can you make?
I can't make no bond. I was wanting to resolve it today. If
I'm-
that's all right. So I can
yeah.
go to work.
I'm not going to resolve it today because in this particular case, there was no recovery of what was accused of being taken. So I don't resolve those cases at magistrate hearing. There's a bond of $25. The state is asking for a bond of $100. Doesn't sound like he's a candidate for pretrial if he's got multiple of these this year. I mean, I'll leave the bond at $25, and if you can't bond out, you'll see your division judge on it when the charges get filed, if they do, okay?
And Your Honor, I just asked for an order of no return to Logan's Beach Bar.
Yeah, so if you're able to bond out, part of your release terms is that you cannot return to, what is it called again?
Logan's Beach Bar?
Logan's Beach Bar. Okay? All right, good luck to you. All right, Williams, Robertson.
Mr. Robertson.
All right, good morning, sir. You're here on one count of violation of probation. It's a misdemeanor offense. There was a bond that's already been set by your judge at $1,000. You have a hearing before your judge on the 21st at 1:30. So you'll go see your judge if you can't make that $1,000 bond, okay?
Good luck.
All right, good luck. Ramon Gonzalez, do we have him?
No, Your Honor.
Okay.
He's back in the jail, but
Okay.
he's no longer a medical loan, but he is a medical reset.
Understood. Okay, so we'll reset him. Was this already one where there was a probable cause? Yep. Okay. All right, Andre Vegas. Hi there, sir. All right, you are here on one count of trespass. Based on my review of the probable cause affidavit, I do find probable cause.
Yeah.
Okay, let me take a look here. All right, if you want to resolve your case today, I will offer you something to resolve it, or you can, we can talk about bond.
I'm good. No, hey, I'm all right.
Oh, good.
All right.
Hi. Okay.
All right.
Okay. Do you understand why you're here today, sir?
Yeah, 'cause I'm
You don't
jailed.
don't talk about the facts of the case. I just want to talk about actual today's proceeding. Do you know what I'm here to do as it relates to your case today?
I want to get out.
Oh, I can imagine. I can imagine. But other than wanting to get out, do you understand what the proceedings are about today?
Yeah.
Okay. Have you had a chance to talk to Mr. Reedy?
Mr. Vegas refused to speak to me, Judge.
Okay, all right. All right, Mr. Vegas, I understand that you want to get out today.
Yes.
I know, but I have to make sure that if I offer you a plea offer, that it's something that you can truly consider and have, you know, a thought process about and make a decision, an informed decision about.
All right then.
What's that?
That's it. I get it.
You get it? Okay. All right, so
Yeah.
all right, well, let me ask you a couple questions and we can see if we can work on something. Raise your right hand. Do you swear to tell, the other one? As best you can. That's okay. That's good. Perfect. Do you swear to tell the
Yeah.
truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. All right. As far as the case today, do you want to resolve your case or you want to fight the charges?
Yes.
Which one?
It's it. I'm done.
Okay.
You know?
Well, but do you want to try and fight the charges and have an opportunity for trial?
No.
Okay.
Damn.
All right. You're adamant. I understand that. Okay.
Get out.
I know you want to get out, sir, but I have to make sure that if I am going to accept a plea today, that you're doing it knowingly and voluntarily.
Yeah, I am.
Okay. All right.
But damn.
I'm a little concerned. You know,
Why?
well, my concern is this, is that I want to make sure that you can fully understand the consequences if you do enter a plea.
Yes, I did.
All right, and what would be the consequences?
Not guilty. No, not time served, man. I tell you, I don't know.
All right, I don't feel comfortable resolving the case today. I'm going to sign an order transferring it to Judge Lerner Wren's division. I'm going to leave a $25 bond in place. I'm hopeful.
Oh,
I know. I'm hopeful that you can bond out. In any event, we're going to transfer your case to Judge Lerner Wren.
damn. You fucking stupid shit. Fuck
Okay.
that.
All right, thank you, sir. All right, Curtis Trailer.
Curtis Trailers and medical reset.
Okay, will do. Thank you. All right, Bradley Vaughn. Conti. Thank you. Okay, so is he finished with his sentence? Okay, so there's no other holds but this one? Okay, all right, sir. You're here as it relates to a traffic capias. Give me 1 second, I'll tell you the nature of that. It looks like it was perhaps a panhandling-like
Yes.
charge, I think. Yeah, here we go. So pedestrian obstructing traffic without a permit. So this is what's holding you in, because it was ad charged. I guess you are about to be released and they found this. Okay, all right, and it looks like the... Okay, all right. Well, let me just take a quick look. All right. Did he go to court? He had an arraignment.
Your Honor.
Yeah, the court yesterday.
On it. Yeah, this was from, what happened was, Your Honor, he was arrested on felony drug charges while he was he probably got an NTA in this case.
Yeah, I was gonna say,
While
because he had a court date
yeah,
on the
while
11th.
While he was in custody on the felony, his arraignment was scheduled.
Yeah.
He obviously couldn't go there because this is out of the satellite. They're not allowed to transport in custody to satellites.
Okay.
So the capias was issued.
Okay.
He pled out the felony drug charge to a possession of drug paraphernalia yesterday. This month. I don't know exactly what date. It was adjudicated, credit for time served. The state would make the same offer to resolve this matter.
Okay, and I want to make sure that there's not going to be a new capias that's issued for the no-show on this.
Well,
That would be resolved if we resolve the case.
Assuming the case is resolved, then yeah, there won't be a capias because
Okay.
the case.
I just want to make sure.
capias.
Okay, if you want to resolve the case today, I can do that. Is that what you want to do?
Yes, ma'am. I'll
Okay.
be getting out tonight finally, right?
Well, I can't promise you the exact time because that's up to the
Okay,
jail.
right.
And I don't know, hold on, I don't know if there's anything else out there because I don't have the ability to search at this moment to see if you have any other active warrants, anything of that nature. But if this is the only thing holding you in, once they process the paperwork, if I accept your plea, then you will get out, okay? So, do you swear to tell the truth, the whole truth, nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. All right, so we talked about the nature of the charge. Do you need any more time to consider this case?
No, ma'am.
Okay, and do you understand that if you resolve your case today to a plea of no contest, you're not going to have any further court dates and you won't have a trial in this case?
No, ma'am. Yes, ma'am.
Okay, you understand that? Okay.
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
Is
This
that-
is gonna be time served, right?
I am going to give you time serve on this. Yes,
Yes,
that's
ma'am.
what the state offer. I don't know if you heard
Okay.
him, but he did offer
Yes,
that,
ma'am.
and I would honor that.
Yes, ma'am.
Okay, is anybody forcing you or making you enter into this plea?
No, ma'am.
Okay, I'm gonna accept your plea of no contest. It's gonna be adjudication, time served, plus court costs. You need, what, a year to pay, 6 months to pay?
Year.
A year? I'll give you a year to pay. All right, good luck to you, sir.
What time?
Here you go. Thank you. Okay, Calvin Flowers.
North Broward.
Hi, sir, how are you? All right, so,
I'm crazy.
okay, good to know. All
I
right,
need to see John F. Kennedy.
okay, all right.
Can you see?
I'm going to advise you, probably don't want to say anything else because I don't want you to say anything about the facts of your outstanding cases, anything that's open, because everything's being recorded, okay?
Yeah.
Okay, all right, so it looks like you're being charged with an outstanding warrant that was out there, and it looks like it's an ad charge for grand theft in the 3rd degree. There's $1,000 bond on that, okay?
Grand Theft, what is that?
Well, I don't have your paperwork, sir, so I can't give you a date, but what will happen is, looks like this is an ad charge. Do you have an attorney right now?
What's the outstanding warrant? What that is?
An outstanding warrant is a piece of paper that's signed by either a judge or by a clerk that gives them the power to bring you into custody or keep you in custody on a case.
I don't. Well, can you tell me? John F. Kennedy told me that I could go to his house later on. And can you please take me to John F. Kennedy's house?
Okay, I can't do that, but in any event, you are going to be held with a $1,000 bond on this case. And does he need any sort of orders or?
I don't think so, Judge. Harrison Joss from our office is representing
Might
Mr.
wanna just
Flowers.
let him know he's ad charged.
Yeah, I will send him a notice.
Okay, so your lawyer's going to get notified of this, okay?
Notify what that is. Is that
They're gonna, we're gonna tell your lawyer that you got another charge added, okay?
another charge?
Yeah.
What that is? I don't know what that is. man.
Okay, your lawyer's gonna come and explain everything, and that way you can understand, okay?
Okay, I don't understand. Everybody trying to kill me. You a terrorist, right? Ain't you a terrorist?
Don't say anything about your case, Mr. Flowers.
It's okay,
I don't
sir.
know who you is. Is you the judge?
I'm the
Or
judge,
you
sir.
you
Okay,
the judge or what?
have a nice day, sir, okay? I don't want you to say anything else that potentially could affect your cases, all right? All right, bye-bye now. All right, I have Alan Hall. Okay. All right, good morning to you, Mr. Hall. You're here on 2 ad charges, so it's account 2 and account 3. They're felony capiases from ad charging, and they're both robbery with firearm charges.
Yes, Your Honor, what happened was when Mr. Hall was first arrested, he was arrested on 1 count of robbery with a firearm. The allegations list 3 total victims.
Okay.
So he was originally, proof evident or presumption great was found on the 1st count. He was held no bond. We just added the other 2 counts for the other 2 alleged victims. If you'd like, I have printed out some paperwork. If you'd like to review it, I showed it to Mr. Reedy. He's aware of it.
Okay, and what are you asking for as it relates to bond on this case?
Seeking no bond on the additional 2 counts.
Okay, so I think I need to consider the paperwork, and that way I can make some sort of finding, if at all. Thank you.
And Your Honor, just to advise the court, what I provided is, 1, the original probable cause from his arrest, and the arrest warrant affidavit for his co-defendant who is listed on the information that I've also
Okay.
provided.
All right, sir, just give me just a little moment here. I need to read through some paperwork, okay? There's already been probable cause found on your case. In fact, there's already been charges filed as it relates to these new two separate robbery firearm charges, but I have to make a finding as to whether, since proof evident presumption, great, because the state is asking for you to be held no bond, okay? So hang tight, hang tight. Okay, I've reviewed the documents that were provided to me, including the information, a warrant to arrest for the co-defendant, as well as a probable cause affidavit for Mr. Hall. Okay, do you want to make argument?
Your Honor, I'm just relying upon the documents provided to the court.
Okay, Mr. Reedy, anything?
In light of the fact that Mr. Hall is currently being held no bond on count one, we would reserve any argument regarding proof evident presumption great until he can get in front of his division judge. I see that an attorney from our office has already discussed this with Mr.
Okay.
Hall at the jail, and I discussed this with him earlier this morning.
Okay, all right. So based upon my review of the documents that I stated before, I do find proof evident and presumption great. I am going to be holding you no bond. This is without prejudice for you to address this with your division judge and see if they might change their mind. All right, good luck to you. Ooh, this goes back to you, sir. All right, good luck, sir. So it's going to be a no bond on both counts. There we go. Okay, I have Fritz Poulard. All right, good morning to you, sir. You're here on an ad charge, so this is count 5, aggravated battery with a deadly weapon. There's already been probable cause found in this case. As it relates to bond, what state position?
Your Honor, Mr. Pollard is being held no bond, court order no bond on a pending case of grand theft and resisting without violence. Apparently, he was being supervised by pretrial and violated.
Okay.
Based on that and the level of violence in this case, Your Honor, I'd be requesting a $10,000 bond in order of no victim contact.
Okay. Mr. Reedy, anything?
No, Your Honor. Mr. Pollard's currently being held, as the state says, counts 3 and 4 are both no bond holds. He
Okay.
needs to go in front of his division judge. I will let his public defender, Kia Love, know what's happening with his case.
Okay. All right, so sir, I am gonna grant the state's request for a $10,000 bond. It's not gonna affect your bond status right now since you're being held no bond on other charges. I'm also going to order no alleged victim contact.
And, Your Honor, that would be,
Have it.
I have it here. Cassidy Maddox.
Okay, so no contact with her. Okay, good luck.
Thank you.
I have Jermaine Smith.
He's here, present, Judge of Maine.
Okay. Okay, Mr. Smith, you're here on a couple ad charges for violations of probation. There are no bond holds with both of those counts. You're gonna see your judge on the 3rd at 8:30 a.m., so good luck to you. All right, Joshua Funicello or Funicello?
Conti.
Monticello, you said it right first time.
Okay, all right. Nope. Okay, all right, so you're here on 3 ad charges, the first being a burglary of a dwelling, armed. The second is a grand theft of a firearm, and the third is grand theft 300 to 5,000. Based upon my review of the probable cause affidavit, I do find probable cause, and there is, these are ad charges here as well. State, what's your position?
Your Honor, on count 7, it's a punishable by life offense. The state is going to be seeking a no bond hold, arguing proof evident or presumption great for first appearance purposes only, based on the physical evidence obtained in the, that's listed in the probable cause affidavit, including the DNA match to Mr. Funicello from the blood that was left at the scene.
Okay, any response?
Your Honor, Mr. Funicello is currently being held no bond on counts 1 through 6. As I explained to him this morning, we will be reserving any argument regarding proof evident presumption great until he can appear before his division judge.
Okay, all right, sir, well, I am going to be finding that there is proof evident presumption great for purposes of this magistrate hearing. You will be held no bond. On counts 8 and 9, you have a $1,000 bond on those, so it's not gonna change your bond status, no bond.
Thank you.
Okay, Thomas Blankenship.
He's here, present, Maine. He is approaching, Judge.
Good morning, sir. You're here on 1 count of possession of drug paraphernalia, 1 count of driving while license suspended, habitual. Based on my review of the probable cause affidavit, I do find probable cause. As it relates to the bond, does anyone want to speak to that?
Judge, in speaking Mr. Blankenship, from what he advised me, he cannot afford to post a monetary bond of $750. He's asking Your Honor to consider releasing him on pretrial release. He lives with his mother in Fort Lauderdale in an apartment. He's been staying at that apartment for about 3 years. He is working. He works for a company, a safety and security company. He does installations. He's like a laborer. He gets about $10 an hour part-time. He's been with that company now for about 5 years. So, Judge, at this time, he does have a residence, so we'd be asking you to consider releasing him on pretrial release.
Well, I know he has priors as far as driving while license suspended. Any other priors or failure to appear?
One moment, Your Honor.
Sure.
He had a possession of heroin and fentanyl last year, possession of THC 2014, theft 2014, theft 2013. Does pretrial show if there's any prior failures to appear?
Okay. I'll release him to pretrial with a monitor. So I will release him to that. Just make sure, sir, you come back to court, okay? No, not complete lockdown, but you're not allowed to drive, sir. You cannot drive without a valid license, okay? Does he need me to waive the electronic monitoring fee?
Judge, let me ask.
Okay.
He does have failures. He does have failures to appear.
He does?
Yeah, he was arrested in his possession of heroin and fentanyl. He failed to appear at a status hearing, and a no bond capias was issued. That was December of last year.
That was only.
No, I understand.
Judge, in speaking Mr. Blankenship, he said he could probably scrape up the $5, but right now, like I said, he's only working part-time. He helped other out, so, he'd appreciate it if you would consider waiving the cost of the $5 per day for the, monitor.
Your Honor,
Hold on.
then I'm showing. Yes, he, looks like I see at least one other KPS issued, yes, February of 2016, and this is from his 2014 THC case. He failed to appear at a status report hearing, and a no bond KPS was
Is it
issued.
this, it was a different hearing than the other one?
Yeah, the other one was in December
Okay.
of last year. This one was in,
All right,
February
I'm
last year.
gonna leave the bond because we just found 2 KPSs and that was just through the 2 cases that they looked at. So even though pretrial may not have seen it, we found them in the record. So I'm not gonna put him on pretrial. He can bond out. Good luck, sir. Okay, Alex Sherlock?
Mr. Sherlock, come on up.
All right, good morning, sir. You're here on 1 count of aggravating fleeing with injury or damage and 1 count of violation of probation, which looks like it's out of county. Based on my review of the probable cause affidavit, I find probable cause for aggravated fleeing and eluding, but I didn't see any injury or damage.
I agree, Judge. I didn't see, it says he went on the shoulder of the road, but there's no indication that there was any damage.
Yeah, I think they just typed it in incorrectly, unless state, did you see anything else?
One moment, Your Honor, I
Sure.
just want to check, because this is one of those statutes where there's a lot of different subsections.
Okay. All right, and sir, just while they're looking at that, I can tell you that the probation case, it looks like it's out of Miami-Dade County, and that's a no bond hold on that case.
Your Honor, under 316.1935, subsection 3A, any person who willfully flees or attempts to elude a law enforcement officer in an authorized law enforcement patrol vehicle with during the course of the fleeing or attempted eluding, drives at a high speed or in any manner which demonstrates a wanton disregard for the safety of persons or property, commits a felony of the 2nd degree. Noting, Your Honor, that the officer even notes that he had to disengage because of the defendant's driving pattern.
No, I find probable cause for ag fleeing and eluding, but this one says aggravated fleeing with injury or
No,
damage.
and I'm saying under the subsection I just read, what I just read is under a different subsection, and it's still a 2nd degree felony.
Oh, understood. Okay, so the probable cause for the other charge isn't gonna change the status of the,
It's just a data entry thing. When you put in the statute number, this is what pops up, and
Okay, well, what I'm gonna do is this. I'm gonna find probable cause for simply aggravated fleeing and eluding.
Sure.
And what's your position on bond?
Your Honor, I would also note, and those charges were still open, right? When he was ultimately arrested in Dade County, go to CC, he was
Right.
charged with fleeing and eluding, grand theft auto, trespass, and possession, I believe possession of marijuana. He was,
Are those pending charges in Miami from the
CCIS.
arrest? Were they split
I'm
up?
checking to see what happened.
Okay,
Go down one. Never mind, Your Honor, it appears those were dropped. But, Your Honor, I would note that I am concerned he's fleeing from law enforcement while, based on count 2, he's on probation for a grand theft. State would be requesting a $5,000 bond on count 1.
okay.
Go ahead, Hector.
Because they usually have more information, so I'll let them finish when they finish.
I think they're finished.
Okay, then. Judge, and speaking of Mr. Sherlock, he's been residing in South Florida his whole life. He lives in Pembroke Pines with his aunt. He works at a car wash. So there's no set wage. It's depending on the amount of vehicles he washes. He averages, I believe, he told me about $20 a vehicle. He's asking for a bond somewhere in the neighborhood of $2,000. He thinks his bonds could come up with $200. I did advise him he's not going to be going anywhere. Dade County's going to come and pick him up because he still has a no bond hold. So we'd be asking for a $2,000 bond on count one, Judge.
Okay, I'm gonna grant the state's request for a $5,000 bond based upon the allegations and the probable cause affidavit as it relates to the fleeing. So, 5,000 is the bond. Good luck. And it's no bond hold on the Miami case. Okay, Tony Simmons. All right, Mr. Simmons, good morning. You have one count of violation of probation. There's a no bond hold. You're gonna see your judge on the 2nd of January at 9 a.m. All right, good luck. I have Joshua Miners West. Hi, good morning, sir. You're here also on one count of violation of probation. It's a no bond hold. You're gonna see your judge next week on the 19th at 8:30 a.m. Anthony Campos.
North Broward.
He's approaching, Your Honor.
Thank you.
Morning, Your Honor.
Hi, good morning, sir. You're here on one count of violation of probation. It's a no bond hold. You're gonna go to court on Monday, the 18th, so this upcoming Monday at 9 a.m.
Okay, thank you. Have a
Good
good
luck.
day.
You too. Take care. Okay, Joseph Bafaro.
Your Honor, if we could put this on recall, please?
Okay, I'll put Mr. Bafaro on recall.
You want to recall, sir?
All right, Tavares Goldman.
He's here, present, Judge. He's the kind service of the public defender.
Thank you. All right, you're here on one count of violation of probation. It's a no bond hold. Your hearing is set for December 15th, so tomorrow at 9:30 a.m. Okay, bye-bye. Ryan Owak.
North Broward, Your Honor.
Hi, I'm great. Thank you for asking, sir. You're here on 3 counts of violation of community control. All 3 have no bond holds, and you're going to see your judge on Monday, the 18th at 9 o'clock.
Okay, I need to subpoena my probation officer. Do I have time to subpoena him to the courtroom?
Here's the thing,
on,
I can't
Monday?
give you, hang on, I can't give you any legal advice. I can't assist you. I don't know if you have an attorney that's assigned to you or you've hired one, but you need to talk to them about any requests, okay?
Mr. Rowak and I have already discussed it. I have the name of his probation officer in Dade County. I'll do everything I can to get your probation officer here on the 18th, as I told you earlier, Ryan.
That's right, you're the man. That's right, you're the one I spoke to. Thank you so much.
Yes,
sir.
you're right. I am the man. That is correct.
You are the man. You got to take. Okay, thank you so much.
Okay, all right, good luck.
All right, nice day.
Bye-bye. Vincent Dukes?
North Broward, Your Honor.
All right, Mr. Dukes, good morning. You're here on 2 counts of violation of probation. There are no bond holds. You're gonna go to court on the 20th, so next week on the 20th at 8:30.
Hey, Your Honor, can I ask you a question?
Hold on, hang on. Before you say anything, don't talk about the facts of the case, your probation, or the violation allegations, okay? Yeah, so there's 2 separate cases. There's a 2012 case, it looks like it was a grand theft originally, and then a 2013 felony petty theft, possession cannabis, and some other stuff. So yeah, 2 separate ones.
I
Don't,
was on probation for those charges.
yeah, so you have,
I got one violation for.
Don't say anything else, Mr. Dukes.
sir, anytime that there's an allegation of a violation, they put it in a warrant. I've got 2 warrants here, 1 on each case, but they may be the same allegation, I'm not sure. You'll figure it out in court, okay?
Thank you,
All right, bye-bye now. All right, Timothy Massey? Where? Thank you.
Here at Maine, Judge.
All right.
Find the service of the public defender.
Okay. Mr. Massey, you're here on 1 count of violation of community control. It's a no bond hold. You're gonna see your judge on the 21st at 8:30 a.m.
All right, ma'am.
Okay, bye-bye now. Okay, Stanley Harris?
He's here, present, Judge.
Good morning, Mr. Harris. You're here on 1 count of violation of probation. It's a no bond hold. You're gonna see your judge on the 2nd of January at 9 a.m.
Thank you.
All right, bye-bye now. Jerome Wispy? Thanks. All right, right, Mr. Wisby, you're also here on a violation of probation, a no bond hold. You're gonna see your judge on the 19th at 8:30 a.m. All right, Jarnell Sayel. Good morning, Mr. Sayel. You're here on one count of violation of probation. It's a no bond hold, and you'll see your judge on the 18th, so Monday at 9 a.m. All right, Arthur White.
North Broward, Judge.
All right, here we go.
He's approaching her.
Thank you. All right. Hello, Mr. White. You're here on one count of possession of cocaine, one count of possession of methamphetamine, one count of possession of drug paraphernalia, one count of driving while license suspended, and you also have an outstanding capias on a misdemeanor case. It looks like a petty theft case. Based on my review of the probable cause affidavit, I find probable cause for everything except for the driving while license suspended. It looks like the affidavit says it's a no valid driver's license.
Yeah, that's just the booking issue, because that's also the offense that was charged with on the PC affidavit.
Okay. All right. So what I'm going to do is I'm going to find probable cause as it relates to everything with the exception of the driving while license suspended. I do find probable cause for, let me just note that, for a no valid driver's license. It looks like they made a mistake when they put in the booking numbers. But what I'll do is I'll ROR you on that count. So count 4 is going to be an ROR. Let me just, 1 through 3. Okay. Now, as it relates to bond on the other counts, anybody want to speak to that?
Yes, I do, Your Honor.
Okay.
As to count 5, Mr. White indicated to me that he was in custody when the capias was issued.
Okay.
If we can verify that, I'd ask him to be released on that charge.
Okay. Let's figure that out. Okay.
Don't say anything, Arthur, okay?
I'm trying to figure out, looks like, well, I know when the warrant was issued. You see it?
One moment, Your Honor. No, it's not. No, this is a capias was issued because the clerk's office was, BSO was unable to, it was from a summons not being served.
Well, I see no show arraignment.
Oh, wait, one moment here, I'm sorry.
That's okay.
I'm sorry. Okay, August 7th, let me check to see if Mr. White was in custody August 7th.
I was in custody from 6.
Hold on, Arthur, hold on.
All right, we're going to look, sir. We'll verify it.
Yep. You should be ROR'd on that count.
Okay, so I'm going to ROR you on that last count as well. So there's no bond requirement for counts 4 and 5. And Mr. Reedy, what about the other bonds?
Your Honor, I'd ask you to release Mr. White on his own recognizance on count 1 and count 2. These appear to be residue cases. The way things are trending in this circuit right now, the state attorney's office is filing charges like this as misdemeanor drug paraphernalia charges. So I think there's a very good chance that count 1 and count 2 will not be filed at all. And he will come back to court to face the petty theft and the possession of drug paraphernalia charge. But I don't think he's going to be looking at a felony. So I'd ask you to release him on his own recognizance on those 2 counts.
Okay, anything from state?
Certainly, I have no objection if the court wants to take in the amount of drugs allegedly found in consideration for setting bond. I don't believe a straight ROR would be appropriate. He was, the arrest that you were just advised about, that was on a theft, that was down filed from a grand theft and a violation of probation on 2 separate possession of PVPs.
All right, sir, don't say anything, okay? Hang on.
He literally got out of jail last Thursday. He was out a week and then got arrested for this.
All right, well, here's what I'm going to do, sir. I'm going to give you on counts 1 and 2, I'm going to lower the bond, so it's not going to be $1,000. It's going to be $100 on each count. So count 1, 2, and 3 are going to be $100 each. That's a total bond of $300. You're ROR'd on counts 4 and 5. Now, keep in mind, sir, that if you get out, if you're able to post that bond, you have a court date on the 18th, okay? So that's Monday. So you need to go to court on that, the capias case that we talked about. Which was it again? A petty theft. You need to make it to court even if you get out, because if you don't make it to court, then you're going to have a new capias out there, and we don't want that, okay?
Okay, I was told, Judge.
Hold on. Don't say anything about the facts of your case, okay? I know, it's frustrating, I know, but you don't
Yeah, I
wanna,
did.
you don't wanna talk about the facts of your case because everything's being recorded.
Okay, I did 6 months on a petty theft. At that time, during that 6 months, 180 days on a petty theft. And when that one, I knew about this case was one.
Arthur, I would stop talking
And
right
sir,
now.
and sir, hang on, listen to me.
I contact everybody.
Okay,
try to
but
get it
sir,
resolved.
listen, sir, you're gonna be able to address it on Monday in court, and I'm not requiring you to post a bond on that count at all. I've ROR'd you, so you're clear
okay.
as it relates to having to post a bond on that count, but it doesn't mean that you don't have to go to court, and it sounds like you wanted to go to court, and you're gonna get your opportunity except for Monday. So go to court on Monday. If you get out, if you bond out, you have a 300 total bond on everything else. If you get out, you need to make it to court on Monday or there's gonna be a new warrant for your arrest. So make sure you go to court.
So on the other count, I got $100 on what charges?
Okay, so counts 1, 2, and 3, possession of cocaine, possession of methamphetamine, and possession of drug paraphernalia. Total bond of all that is 300.
Okay.
Okay.
Okay. The job without license. What I have to do?
There's no
Okay.
requirement for bond.
It's not. I just got to buy a ticket. I just got to pay.
Arthur, your total bond is $300. I'll call Ruby to come get you, and your court date on Monday is at 2:00 in the afternoon. You need to be there.
Okay.
All right? Good luck, man.
sir.
If I don't get out, they know I'm here, right?
Well, he's ROR'd, but can they, so there's no bond hold on that count, but they'll bring him to court, correct?
Well, and yeah, I mean, if you want to, I know the deputy at North's hearing everything we're saying. I don't know if you want to, I mean.
All right, North Broward.
Yes, Your Honor.
All right, hi there. If he's unable to bond out, please make sure that he gets to court on Monday for that misdemeanor capias case. I ROR'd him, so they're not going to show him in custody on that case, but he does have a court hearing on Monday for it, okay?
Okay.
So we need to make sure he gets there. Thank you so much.
Okay, because I'll go through that. Okay.
All right, bye-bye. You got it. All right, and
God bless.
thank you. Enrico Nelson?
Mr. Nelson's here at Maine.
All right, Mr. Nelson, you're here on one count of a municipal ordinance and also one count of violation of probation or community control. There's a no bond hold for the probation case. Based on my review of the probable cause affidavit, I do find probable cause for the municipal ordinance. I could tell you it was possession of cannabis. As it relates to the bond on that, I'll leave that at $100 because there's the no bond hold for the probation. So no matter what I set your bond on count 1, it's going to still be the no bond hold. You're going to see your judge on January 2nd at 9 a.m.
Judge, the only thing I'd be requesting is on count 1.
Yeah.
I believe that the arrest was in the city of Fort Lauderdale.
I will confirm that, yes.
I believe the new arrest is the basis of the violation of probation. Mr. Nelson just advised me he would like an attorney on count 1. If it's a city of Fort Lauderdale case, would you appoint the law office of Jarvin Horns?
Yeah, if he qualifies, I'll appoint him. That's fine. What do I need to do? Just sign an order? Okay, that's fine.
Thank you.
Okay, Brandon Rollins.
Mr. Rollins, come on up, please.
All right, Mr. Rollins, you're here today on one count of violation of community control. You have a no bond hold. You're going to see your judge on the 2nd of January at 8:45 a.m.
Good luck, sir.
All right, bye-bye, sir. Okay, I have Raynor McCallum.
Sure, mate.
Okay, sir, you're here on one count, or it looks like 2 charges. Were these warrants? Oh, these are no-shows. Okay. So they're not in custody cases and no-shows. Okay. So count 1 is fraudulent use, possession of an identification of another without consent. Count 2, grand theft, $300 to $5,000. You have 2 capiases on felony charges where you no-showed, one at jury trial and one at calendar call. Those are 2015 cases, 2 separate cases. Those are no bond holds. As it relates to count 1 and count 2, there's already been a determination of probable cause. I'm not sure if anybody wants to speak to bond given the no bond holds.
No, Judge.
Okay, so I'll leave the bond amount as was written, $3,500 and $100 for counts 1 and 2. No bond on counts 3 and 4. And I'm not showing a court date yet, so be on the lookout or speak to your attorney for your court date. All right. Mark Collins.
He's approaching.
All right, good morning, sir. You're here on 2 separate court orders for juvenile cases, or it looks like 1 juvenile case, 2 separate no bond holds for that. You also have a misdemeanor capias that has a bond of $250. As far as the, I'm guessing, is it the misdemeanor that he has the court hearing on Monday? It looks like it. Okay, so you have a court hearing on the misdemeanor case, and that is on Monday, this Monday at 2 p.m. So you'll go to court on Monday for the misdemeanor, and then I guess the juvenile will bring you to court for that. And just so you know, the misdemeanor charge was the possession of cannabis. So it's $250 bond on that one, and then the other juvenile holds are no bond. Good luck.
Oh,
Michael
she
Shea.
stepped down for a minute. She'll be right back.
North Brown. He's approaching.
Thank you. All right, good morning to you, Mr. Shea. You're here on 1 count of grand theft, $10,000 to $20,000, 1 count of fraud, uttering a false instrument, 1 count of dealing in stolen property, 1 count of false information to a pawn shop, less than $300. You have an out-of-county hold, as well as a violation of probation. So, and it looks like that's out-of-county as well. The violation of probation and the out-of-county hold, those are no bond holds. As it relates to counts 1 and 2, I find probable cause based on my review of the probable cause affidavit. The other 2 counts, counts 3 and 4, those were already done, it looks like, by some sort of warrant. And there is on counts 1 and 2 a bond of $1,000 each. On count 3, it's $3,500. On count 4, it's $1,000. Does anybody want to speak to that?
In light of the no bond holds, Judge, he's going to need to resolve those in front of a division judge.
Okay, so go ahead.
So the only thing I would be asking, Your Honor, is just an order of no contact with Robert McNaka.
Okay, so I'm gonna leave the bonds as they are. You do have the out-of-county hold and the violation of probation from another county as well. Those are no bond holds, so you're not gonna get out even if you were to bond out. I'm going to order no contact with the alleged victim on, is that the 15 case? Or the,
No, I believe it's the.
is that the ones here today?
Yeah, that's
Okay.
the new charges.
And it's Robert Minaga. All right, good luck.
Am I able to say one thing?
Okay, let me just say this. Everything that you say is being recorded, so you don't want to talk about the facts of any of those cases, okay? Because you don't want to implicate yourself and them have a recording of it. With that being said, if you want to say something, I'll swear you in.
Okay.
Hold on. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, go ahead.
Your stance on like mental evaluations, because right now I'm on suicide watch, and the last time I was in trouble was 2.5 years ago. That was the other time was in Palm Beach. I don't bode well with this. So
Okay.
last time they had me go directly into an inpatient facility. I'm just trying to see what you guys offer instead of, because I'm here.
Yeah, I'm going to flag your case, Michael. We'll have somebody up to see you shortly.
Okay.
All right, if not today,
appreciate
tomorrow, I'm gonna make it a priority that somebody sees you as soon as possible.
Okay.
You gonna be able to hang in there until then?
Hospitalization is a lot better than what I have right now. I haven't spoken to an attorney, a family member. No one's allowing me to make any phone calls.
Is there somebody I can call for you?
My sister, but
What's her name?
Natasha,
What's her number?
954-607-7400.
All right, I'll call her. Meanwhile, hang in there. Somebody will be up to see you very soon, and we'll discuss those issues when we do, okay?
Thank you, Your Honor. Thank you, sir.
Okay, good luck, Michael.
Bye-bye. All right, Dalvin, President.
He's here, Maine. Good morning.
Hi, sir. Good morning. You're here on 1 count of grand theft, $300 to $5,000. 1 count of battery on a law enforcement officer. 1 count of fraud, uttering a false instrument. 1 count of criminal mischief, $200 to $1,000. You also have 2 out-of-county holds, but they look like they're RORs, perhaps. So I'll
Yes,
verify
they
that. Okay. Based on my review of the probable cause affidavit, I find probable cause for everything except for count 4. I find probable cause for second-degree criminal mischief because there's no dollar amount. So what I'll note is I'll just note that, and for count 4, I'm gonna give you an ROR and we'll talk about bond for the other counts.
One moment, Your Honor. Now I'm just looking up that warrant. Yeah, I mean, I don't see anything here about that. I don't.
They're from Polk County.
Yeah, and it says full extradition. I don't know why. I mean, I don't doubt the jail. I don't know why they would put it would show full extradition when there's an ROR in it, but.
To be ROR upon arrest. I mean, that's what I'm reading as far
Yeah,
as
yeah,
the
no,
printout, yeah.
it's a little unusual. I can tell you what I'm showing here was a failure to, based on a failure to appear. Cases. Okay. Your Honor, just based on the allegations, I would be requesting a $2,500 bond on count 2.
All right, and defense, your position.
Judge, he's 28 years old. He's been residing in Florida for his whole entire life. He is working. He works at Capitol Grill. He's been there for about 6 months now as a dishwasher, making about $12 per hour. He lives with his mother in Lauderhill. Been residing in the same location now for about 5 months. Their monthly rent is about $900. He helps his mom with all the expenses. She's currently collecting disability about $700 per month. Judge, we'd be asking you to consider setting a bond of $1,000 on count 2.
Okay. And as far as any priors that would,
He had
or failure to appears?
well, the failure to,
Yeah,
I
up
mean,
in Polk County.
In 2015, he had a theft and conspiracy to commit theft out of Osceola County. He went through pretrial diversion, possession of cannabis, misdemeanor out of Broward in 09.
Okay. All right, I'll grant his request for a bond in the amount of $1,000 on count 2. So it'll be count 1, $1,000, count 2, $1,000, count 3, $1,000. Count 4 is gonna be ROR'd, and then the out of counties, they're already ROR'd, so it's gonna be a total bond of $3,000 for him to get out. All right, good luck.
Thank you, Judge.
Okay, Paul Delacre?
He's approaching.
Good morning, sir. You're here on one count of delivery or distribution of Xanax. Based on my review of the probable cause affidavit, I do find probable cause. See a candidate?
I would take issue with that, Judge.
Okay.
It appears from my reading of the probable cause affidavit that Mr. Delauchery, first of all, had a prescription for these
Right.
Xanax, so he's not charged with possession.
Right.
The only evidence against him is that the officer observes 2 hand-to-hand transactions in exchange for currency. The officer cannot say, and there is no probable cause to establish, that Mr. Delauchery was handing anybody any type of narcotics or contraband at all. It requires a total assumption that this is what those hand-to-hand transactions were about, without the officer being able to say what was exchanged. There's no way that the court could find probable cause to say that he was distributing Xanax. And the other evidence in the probable cause affidavit is also extremely circumstantial, just stating how many pills he had a few days before and how many he had a couple of days later is not enough to establish probable cause that he was distributing Xanax.
He was stopped driving the same vehicle that an anonymous caller stated, a white male, driving the same, that came to the location in the same vehicle, was offering narcotics to people, then saw him commit 2 hand-to-hand transactions. I think that's enough for probable cause.
I don't think it's enough for probable cause at all, Judge. We don't know who this anonymous person is, what they saw, how they saw it, where they were standing, what the lighting conditions were like, whether they even know Mr. Delauchery from any previous dealings. So that's to say that a probable cause can be established based on something an anonymous witness who didn't even give their name allegedly says to a police officer I mean, it's just not enough for probable cause.
I mean, I think you have a very good argument as it relates to, you know, the facts of the case, and we'll see if they end up filing the case, but I think that there is enough circumstantially for probable cause on this, so I am gonna keep my finding of probable cause, but I'll certainly consider it as it relates to bond, and
Yes,
is
ma'am.
he a candidate for pretrial release? I mean, does, oh, okay. Well, what about, what's this Margate address? Okay,
And I see a history out of the state of Massachusetts.
okay. All right, well, as far as, I mean, how much can you afford for bond?
Judge, as being Mr. Delroche, he cannot afford anything for bond. He's asking you to consider releasing him on pretrial release. He's homeless, however, he does have a mailing address, and that's located in, Margate, the county of Margate. Judge, he's able to receive notices, he's gonna be able to know when his future court dates are, and he will appear in court. Right now, he's not working, he's, collecting disability. He gets about $735 per month. He can't even afford right now a place to live, so that's why he's homeless. He's been here in South Florida for 1 year. He's from Boston, and he has no one here in the community that can post any sort of monetary bond. Judge, I'd ask you to, I realize that the court found probable cause. One of the things you can look into is as far as the strength or weaknesses of the state's case. Most likely, may not even be filed as per he was arrested. I'd ask you to take that into consideration and release this gentleman on pretrial release, Judge.
Your Honor, it's just, in my opinion, it doesn't make sense to put someone that's clearly transient, when interviewed by pretrial, states his residence is in Massachusetts. How can they supervise him where at any time he can get in his car and say, I'm going back to Massachusetts. There's no reason for me to stay in South Florida.
Does he have failure to appears?
There was a warrant, I see a default warrant in Massachusetts issued in 2014. I do have previous arrests with no dispositions. I don't know if pretrial has dispositions on those. Yeah, it just isn't in the system. But frankly, Your Honor, even if he didn't even have that warrant issued, I mean, putting him on pretrial and ROR him to pretrial, what motivation is there really for him to stay?
Well, let me ask him, Mr. Delacre, and I'm sorry if I'm saying that wrong.
It's Delucre.
Okay, Delucre, thank you. All right, and you don't have to say anything. If you want to speak through Mr. Romero, that's fine with me as well. But it's my understanding that pretrial interviewed you and that you didn't want to give them information or you weren't cooperative. You don't have to answer to that. But if I send you to pretrial release, if I give you an opportunity to not have to post a bond and just be monitored by pretrial release, are you willing to cooperate with that?
Yes, ma'am.
Okay, and do you understand that if I send you to pretrial release that you're gonna have to check in and that you're also gonna have to return to court if they file charges? Do you understand?
Yes, ma'am.
Okay, and even if you're not staying at that address, you have an obligation to check the mail and also to make sure that you receive any notices, things of that. That's gonna go to that mailbox, and you're responsible for checking that every single day.
Yes, ma'am.
All right.
And Your Honor, and I just want to note this because I didn't realize this at first, and it gives credence to what pretrial was advising you. And I'm concerned about how compliant he will be. When he was interviewed by pretrial, he was, disruptive. They couldn't even book him. If you look at his booking sheet, Your Honor, under intake comments, they had to book him by his probable cause affidavit due to violent behavior. If he won't even, if he won't even assist in the process of getting booked and interviewed by pretrial, how much confidence can there be? I mean, I know he's saying it to you right now when it's dependent on his ability to get out without having to post a bond. So he has a motivation to tell the court anything that he thinks will assist in him getting pretrial. But when that isn't an issue and all he has to do is give information, he acts violent, they have to book him by his PC. when he's being interviewed by pretrial so they can assist him getting out of ROR. He's disruptive to them. They can't even complete the interview.
Judge, one of the things certainly in this situation, there's a gentleman here that's basically adamant as far as his innocence. He's looking forward to his day in court. From his point of view, he has a valid prescription. As far as my colleague's argument, as far as the likelihood, as far as it being filed with possession or intention or anything like that, I believe at this time is quite minimal. So most likely, the only charge they're actually going to consider is a simple possession. Once his attorney probably gives a valid prescription, that case is probably going to be no info. From his point of view, I can understand the frustration, and maybe that may help explain the situation as far as why he was so frustrated. Right now, he's having a conversation with you, and he's saying that he can abide by the conditions of pretrial.
Okay.
I'm sorry,
Mr. Linder, go ahead.
I couldn't disagree with Mr. Romero more. First of all, he's being accused of distributing. That he has a prescription is meaningless. I have a prescription medication. That doesn't mean I have permission to go out and sell it to people. And, Your Honor, based on the evidence, and this is just a PC affidavit, as the court knows, there's going to be more reports that are going to be provided. And so I'm not looking to relitigate the issue. The court's found probable cause. So the fact that he's a prescription really is irrelevant.
All right, this is what I'm going to do. I'll permit him to go to pretrial release, but part of that is that you, sir, have to cooperate with them by providing them information. You have to understand that pretrial release and the people that are going to work with you as far as getting your information, they have nothing to do with whether charges are filed in your case or not. So although you may want to talk to them about your case, that they literally can do nothing with that information, okay? So you need to take that information and speak to an attorney or someone else that could then further the process of your case. What you need to talk to people at pretrial release about is where are you going to be living, where are you going to be receiving notices, and what you are required to do to check in with them, okay? So please make sure that you cooperate, because realistically, if you're not cooperative with them and they can't verify the address and they can't do those things, they're not going to be able to take you out of jail. So it's in your best interest to give them assistance in providing that information. That way they can at least try and verify your address and get you out. And then at that point, you can speak to an attorney, and that attorney can assist you with your charges, okay? So please work with them, because I don't want it to be a situation where I let you out and either they can't confirm an address and then you can't get out because of it, or you get out on pretrial release and then ultimately you don't comply with the terms of it because of your frustration about the case, okay? So realize who you need to speak to about your case and realize who you need to speak to as far as terms of your release, okay? You understand?
Yes, ma'am.
Hold on. Is it 7460 Margate Boulevard?
Oh, yeah, 7460 Margate Boulevard.
Okay, and that's,
It's a house.
it's a house. Whose house is that?
It's my wife's grandmother.
Okay, and you're allowed to receive mail there?
Yeah.
Okay, and if pretrial calls her, are they gonna verify that that's true?
Yeah. I received mail there now.
All right. Well, I'm going to release you to pretrial pending that verification, okay? If they can't verify it, if grandma says that no, he doesn't receive mail, we don't accept him here, whatever the case may be, you might have to go before your division judge and seek an alternative for release, okay? All right, so I'm going to release him to pretrial pending verification. Okay, Serge Sando.
Mr. Sando is here present, Judge. He declined the services of
Hold-
public defender.
All right, hang on 1 second. I need to bring back who? Yes, the previous, Mr., I said it wrong the first time. Delauchery? Hi, sir, come on back real quick. Yes. Yes, absolutely. Okay, so pretrial's gonna start working on verifying the address. You said it was your either wife or ex-wife's grandmother. What's her name?
She's my girlfriend, Christina.
I'm
Davis.
sorry. Okay, no, the grandma's name. Who owns the house?
Kathleen Williams.
Kathleen Williams, and do you have her phone number?
Yep.
Okay, what is it?
754-207-4742.
Okay, so 754, say it again slowly.
207 4742.
Okay, they're gonna start working on that. Anything else that you guys need for that? Okay, thank you. Okay, sorry about that, Mr. Sando. Come on up. All right, good morning to you, sir. You're here on one count of grand theft of a firearm, one count of carrying a concealed firearm, one count of possession of weapon or ammunition by a convicted felon, one count of possession of cannabis, 20 grams or less, and also a ticket for improper left turn. Based on my review of the probable cause affidavit, I do find probable cause. I'm going to hear now about state's position and defense position as it relates to bond.
I think he declined the public defender, Your Honor.
Okay, so then state's position, and then I'll hear from you, Mr. Sando.
Your Honor, his criminal history, 2014 out of Palm Beach, sale, delivery of opium or opiates. He was convicted on 2 counts and convicted 1 count of possession of a Schedule II controlled substance. 2014 out of Palm Beach, possession of Schedule II controlled substance, 2 counts, and misdemeanor possession of marijuana. Based on his criminal history and the allegations in this case, state would be requesting a $5,000 bond on count 3, also considering that it was a stolen firearm.
Okay. Okay. So, Mr. Sando, you've refused the services of the public defender. That's okay. What I'm going to do is I'm going to swear you in. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Understand, please, that everything that you say is being recorded and can use against you. The state is asking for a bond in the amount of $5,000 as it relates to count 3. You also have other counts that I need to consider for bond. So if you'd like to tell me anything about your ability to bond, tell me that now.
Well, my girlfriend would bum me out, but she can't afford too much because she got 2 kids and stuff like that.
Okay. All right. Right now, if I were to grant the state's request, it would be $5,000 on count 3. Frankly, I'm not comfortable with count 1 as far as being $1,000 bond. I would be increasing that bond to $3,000. So it would be $3,000 on count 1, $1,000 count 2, $5,000 on count 3, $100 on count 4. So that would be a total bond of, one second here. So that would be a total bond of $9,100. Can she make that bond if she works with a bondsman?
Probably could do a little lower, Judge.
I mean, is there anything else that you want to tell me that I should be considering?
It's all right. I'll try to figure it out.
Okay. All right. Good luck to you, sir.
Thank you.
Yeah, so count 1, $3,000, count 2, $1,000, count 3, $5,000, count 4, $100. Okay? All right, Chad Lowe.
This is from August 2016.
Mr. Lowe is here, present, Judge Amin. He's approaching, Judge.
Thank you.
He didn't sign up with the public defender's office.
Okay, thank you. Good morning, Mr. Lowe. You're here on 1 count burglary of an occupied dwelling unarmed, 1 count of grand theft 3rd degree, $100 to $300. This was based upon, for these capiases.
This is not in custody.
Okay, so these are not in custody capiases. There's already been a probable cause determination. State, what's your position on bond?
Your Honor, the state is going to be requesting on count 1 a $25,000 bond, $5,000 bond on count 2. Should he post his bond, that he be supervised by pretrial release services with a GPS monitor level 1. The reason being is, Your Honor, Mr. Lowe currently has a pending strong arm robbery. Now, this predates his arrest on that, so this wouldn't be a violation of his.
Okay.
But the reason, in addition to the court should know that it's pending, that case is in Rock Court. I imagine this case will also be going to Rock Court.
Got it.
So he's facing even more significant consequences if convicted. Noting the evidence in this case, I would also want to advise the court, his criminal history, is that him or someone else? Okay. 2014, he was convicted of strong arm robbery. He was sentenced to just under 16 months in state prison as a habitual offender. 2014, possession of cocaine. Again, just under 16 months. He's had convictions, 1, 2, possession of cocaine, delivery of cocaine, aggravated fleeing and eluding, grand theft auto, another grand theft auto. He's gone to prison on all these cases. He's gone to prison in the past, classified as a habitual offender.
All right, let me look real quick. All right, Mr. Lowe, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, all right, so the state is requesting a bond in the amount of $25,000 on count 1 and $5,000 on count 2. Without saying anything about the facts of the case, is there anything that you want to tell me as it relates to your ability to bond out?
No, ma'am.
Okay. All right, well, I will grant state's request for a bond in the amount of $25,000 on count 1, count 2, $5,000, total bond $30,000. If you are released, then you'll be released to pretrial release with a GPS monitor. Good luck to you, sir. I can't hear you. He can work.
Well, all right.
If he can get out, if he can post that bond and then he's on a monitor, then he can work. I'll waive the fees. Okay, Marco Sainville?
Who did you call?
Oh, Mr. Sainville? Is that you? Your bond was posted.
No, that's not him. I don't think he's there.
Oh, okay, Mr. Sainville's bond was posted. All right, I have Louis Bruno.
He's here.
Okay, Mr. Bruno, good morning to you. You're here on 4 counts of battery on a law enforcement officer, 1 count of disorderly conduct, 1 count of resisting or obstructing an officer with violence, 1 count of trespass, and also a violation of probation, a misdemeanor case, it looks like, with a no bond hold on that. As it relates to the other counts, counts 1 through 7, based on my review of the probable cause affidavit, I do find probable cause. As it relates to bond, what is the state and defense's position?
Your Honor, on counts 1 through 3, state would be requesting $2,500 each. On count 4, $1,000. On count 6, $500. Noting, as Your Honor can see, he's on probation right now for DUI property damage with an enhanced breath. 2001, burglary of a dwelling, 3 years Florida State Prison. 2000, trafficking in MDMA, 3 years Florida State Prison. Battery in 2000. 1995, aggravated battery and 2 counts of aggravated assault. He was sentenced to 6 years in Florida State Prison.
Okay. Mr. Romero?
Judge, he's 39 years old, been residing in Florida his whole life. He's currently working. He was working for a company called Peak Performance. He's a mechanic. He makes approximately $650 per week. He lives with his father in Plantation. His father is also a mechanic. That's the person he's going to be contacting to help post his bond. Judge, from what he advised me, we would be asking for you to consider setting a bond on counts 1 through 4 as far as $1,000 each, leaving the 2 standard bonds in place on 5 and 7, and we would be agreeing on count 6 with the state's request of $500. And besides that, Judge, we'd be asking you to sign a photo order.
Okay.
And Your Honor, I'm sorry.
Yeah, it's okay.
The only other thing I want to note, because I was looking to see if the alcohol influence box was checked off, but they make a note that Mr. Bruno was intoxicated, and I also imagine, I have to imagine one of the conditions that Judge Pohl set on his DUI probation was no alcohol.
Okay. All right. What I'm going to do is this. I mean, he's going to be held no bond on the DUI case. So what I'll do is I'll grant the defense's request for bond in the amount of $1,000 on counts 1 through 4. So $1,000 on each count. And then as it relates to count 6, it'll be the $500 bond. The other 2 bonds of $25 will be in place. There's a no bond hold on the misdemeanor violation of probation. He'll go see his judge on the 19th at 9 a.m. And I will grant your request to have him photographed.
Yes, thank you, Judge.
Okay, I have Radivaj Araki.
He's approaching, Judge. Judge, he declined the services of public defender.
Okay.
And I believe at the end, as a friend of the court, at the end, he's going to be asking you to sign an order allowing him access to his phone contact so he can call somebody.
Okay, that will be granted. All right, so is it Araki?
Yeah.
Okay, Araki, you're here on 1 count of aggravated assault with a deadly weapon, and based on my review of the probable cause affidavit, I do find probable cause. First, I'm going to ask state what their position is on bond, and then I'll have a chat with you as well.
Your Honor, Mr. Araki has no criminal history. That being said, I'm going to be asking for a $15,000 bond, an order of no victim contact, and Order that he not be in possession of any firearms or ammunition until further order of the court. The reason I'm making this request is, one, I would note the strength of the evidence, the alleged use of a firearm. Also noting that even though he was only arrested for one count, based on the allegations, it would appear that he threatened two separate people with his firearm.
Okay, sir, if you could raise your right hand, sorry. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. All right, the state is requesting a $15,000 bond. Without you saying anything about the facts of your case, you can address now to me your ability to post bond.
I have a couple of debit cards and credit cards in my phone. I can use probably about $400 and $500.
Okay,
Without
well,
calling anybody.
they're requesting a bond in the amount of $15,000. Do you have anybody that you can contact? If I gave you permission to look in your phone, do you have anybody that you can contact that can post a bond for you?
Yes, I can.
Okay, and how much total do you think that bond could be if you asked a friend or family member to post a bond?
Can I do 1,000?
Say it again?
Can I do 1,000, please, or 10,000?
Well, you tell me what you can afford. I mean, there are some serious allegations, and I don't want you to comment on them, but it wouldn't be a $1,000 bond, so you tell me what you can afford so I can take that into consideration.
I mean, I can afford 1,500, but I didn't want to ask my friend, for 1,500. I want to ask him for 1,000.
Okay.
I mean, I can pay him back, in a couple of weeks. So.
Okay, but as far as a total bond amount, how much can you afford? Are you saying $1,500 total is the maximum?
No, I mean 7,500 or 10,000.
Okay, all right. Well, I will. I'll give you a bond then.
Well, I would just note, Your Honor, from what he's saying, then it would certainly sound like he could, going through a bondsman, afford a $15,000 bond.
Well, what I'll do is this. I'm going to grant bond in the amount of $10,000. I'm going to also require you not to have any contact, direct or indirect, with the alleged victims in the case.
And as far as firearms and ammunition, Your Honor?
And no possession of any firearm or ammunition while you're out on bond, okay?
Understand.
Okay, good luck to you.
Thank you.
Okay, Eduardo Rodriguez.
He's approaching, Judge.
Hi there, sir. You're here on one count. It's actually a violation of parole. There's a no bond hold. I don't have any information of when they're going to speak to you about that, but the Department of Corrections will be contacted, okay?
Yes, ma'am.
All right, good luck.
Good luck, Judge.
Okay, I have Miss Saul or Miss Sael Duvall or Duvale. Okay, sir. You're here on one count of failure to re-deliver a hired vehicle. I'm not super familiar with this charge. I mean, certainly it appears there's allegations that mostly resemble a grand theft auto, but as far as it relates to a re-deliver a hired vehicle.
I mean, basically, a car was rented from Budget Rent-A-Car and wasn't returned at the agreed-upon date pursuant to the contract.
Okay, am I missing something?
Well, it's a cousin to Grand Theft Auto, Your Honor. I mean, it was
No, in the probable cause affidavit. The only thing that it says to me is that it was reported stolen.
I'm looking at above the offense's charge, it lists the name of the victim.
Hold on. Okay, I see what you're saying, Budget Rent-A-Car.
Yeah.
Mr. Reedy, anything?
Well, it doesn't say that the car was rented from Budget. The allegation is it was stolen from Budget. I don't know, in
which
all
one.
honesty, how much of a distinction that really is. I think it's something the court can consider for bond. He was arrested without incident, and his sister, he's got ties to the community, obviously, because his sister came and took custody of his property. So he does have some ties to the community there. So I think that's something else the court can take into consideration.
All right, what's your position on, well,
I
mean, as far as I do see it's Budget Rent-A-Car. I mean, frankly, I think there's probable cause for a grand theft auto. I'm not sure of the distinction in the level of crime.
They're both third-degree felonies.
Right.
They both have standard bonds of 1,000, so whichever pleases the
Okay,
court,
so-
I'm fine with.
All right, well, I'll find probable cause for grand theft auto. As it relates to, for purposes of determining bond.
Let's see.
Does he have priors or anything else I should consider?
Yes, and I don't know, considering his priors, I don't even know if 1,000 is appropriate. He has
Okay.
federal priors, 2005 conspiracy to commit bank fraud, sentenced to 5 years in federal prison. He just got off supervised release. It looks like, actually, I'm sorry, followed by 3 years of supervised release. I'm showing here, and if pretrial can confirm this, that he's on federal supervised release until August 20th of 2018. As far as state priors, according to the Department of Corrections, 1998 out of date, trafficking and stolen property, a year and 9 months state prison. Let's see, trafficking stolen property, grand theft, uttering a forged instrument, grand theft auto, burglary of a dwelling, grand theft, trafficking stolen property, burglary of a structure, grand theft, trafficking stolen property, burg structure, grand theft, credit card fraud, illegal possession of a credit card, grand theft, another grand theft, purchase with a false credit card, and all these charges, he received state prison charges. So I'd be asking for a $5,000 bond, Your Honor.
Okay.
Judge, most of the priors I'm being informed that Mr. Lender read off are about 20 years old. I know his last contact from what he's advised me is about 10 years ago. So we've had a gentleman out of the system for about, not picking up new charges for about 10 years now. At this time, Judge, he is 45 years old. He is working. He's working as a salesman for an auto show company. He's been working there about 2.5 years. From what he's advising me, business is really slow. His paychecks are averaging about $200 per week. He lives with his mom in Hollywood. His mom is retired. He does have other members of his family that live in our community, specifically his sister. From what he's advised me, he thinks that typically she could afford to post a monetary bond, but due to her work schedule, from what he thinks, the soonest he's going to be able to post his monetary bond is in a couple of days. Judge, he's asking you at this time to consider releasing him on standard pretrial release.
Your Honor, I can confirm. I checked his NCIC hot file alert. He is supervised under federal probation. I have the name of his federal probation officer and the contact number with a note that he is to be contacted within 24 hours if there's any contact made with him, any law enforcement contact made with him.
Right. All right, well, oh, sorry, go ahead. Did you want to say something?
Yeah, we were unable to verify the defendant's address. However, his sister did state that she would post his bond tomorrow. She may be able to post his bond.
Well, what I'm gonna do is this. I'm gonna give you a bond of $5,000, and I'm gonna give a requirement also of pretrial release with a GPS monitor. No, it's gonna be the lockdown. I'll waive the cost of supervision. And then he might have a federal hold coming, I'm not sure. Okay, good luck, sir. All right, I have Gregory Booth,
Medical reset.
okay?
And, Your Honor,
Judge, could we have a phone order on Mr. Delavalliant?
Yeah, that's fine. Granted.
yeah, Your Honor, and I know up in North we have Mr. Bifaro left. I apologize. I'm gonna ask if this could be reset for 1:30.
Okay,
I'm trying to get some additional information, and I need to. Well, you know it's filed, right, bro? You know it's filed, right? Well, now you know. So that's why I imagine that, and I would hope a case filer. I'm trying to get some more information because there's not enough in the PC right now, so I want to.
okay. Okay, well, they would have an opportunity to perfect anyway, so
That's why, yeah.
if there was a finding, and I'm not saying there is one now, but, so we'll just reset this for 1:30 then.
Thank you, Judge.
Okay?
Yes, by far.
Yeah. Thank you. Thank you, ma'am. Sorry. All right, guys, anything else for now?
Nothing
Morning? Okay.
further.
Oh, yeah, I'll wait for it. Okay, you know what? Let me just look at it real quick. Well, I guess they're gonna present later. I read this earlier this morning, so let me look while I'm waiting for it. The order.
Calling you about someone you were supervising, Misael Del Valle. He was arrested last evening. Oh. Oh, okay. Okay, good. That's a, yeah.
Oh, yeah, I remember this
All right,
one.
so you're aware of it. Yeah, well, I can tell you that we had his first appearance this morning. The court found probable cause. Basically, he was driving
Yes.
rental vehicle that was supposed to be returned a couple days prior. So they reported his, Fudger Rent-A-Car reported it stolen. He was arrested last night driving a vehicle. I don't have a lot more detail than that. He was the sole occupant of the vehicle. And just so you know, while you decide how you're gonna proceed